Good morning, and welcome to the September 2024 meeting of the SEC's Investor Advisory Committee. I am Brian Shore, and I serve as chair of the IAC. Before we get started, I'd like to turn the microphone over to Danielle, who will conduct a roll call.
Thank you, Brian. Jamila Abston Mayfield.
Present.
Cambria Allen Ratzlaff.
Present.
James Andrus.
Present.
Gina Gale Fletcher. She'll be joining later this afternoon. George Georgiev.
Present.
Brian Helmer.
Present.
Colleen Honigsberg.
Present.
Craig Kanoki.
Present.
Christine Lazaro.
Present.
Nancy Lamond. She'll be joining later this afternoon. Christina Martin Fervita.
Present.
Amy McGarity. She will not be joining today's meeting. Andrew Park.
Present.
Sandy Peters.
Present.
David Roney. Nothing heard. Paul Roy.
Present.
Brian Shore. Jennifer Schultz.
Present.
Andrea Seidt.
Here.
Paul Sommerstad.
Present.
Alice Steinbach.
Present.
Alvin Velasquez.
Present.
Joanne Yu. Joanne's present virtually. Brian, back to you.
Okay, thank you, Danielle. Today's meeting offers a comprehensive agenda featuring two engaging panel discussions on current and relevant topics. Our morning panel, beginning shortly, will be moderated by Paul Sommerstad. Paul is the vice chair of our Investors Purchaser Subcommittee and a partner at Cerity Partners. The panel is going to explore in investment advice, a history and update on who is required to serve in your best interest. In light of the July 2024 Federal District Court stays of the DOL's retirement security rule and related rulemaking, there appears to be uncertainty and confusion among investors as to when their financial professionals are investment advice fiduciaries. Considering those court decisions and the varying definitions of fiduciary under SEC rules, ERISA, and state law, the panel will discuss the differences, similarities, and nuances of financial professionals' obligations to their clients and how this may impact investors. We'll then break for an administrative session from 12:05 to 1:35, followed by our afternoon panel, key topics from securities litigation, shareholder proposals, and tracing in Section 11 litigation, which will begin at 1:40 p.m. This session will be moderated by Colleen Honigsberg, Professor of Law and Associate Dean at Stanford Law School, and Secretary of the IAC and Vice Chair of the IAC's Investor as Owner Subcommittee. Building on recent litigation, the panel is going to examine how well the current regulatory framework protects an investor's ability to submit shareholder proposals and bring Section 11 claims. The panel will highlight two so-called, quote, pain points, close quote, for the securities investors: shareholder proposals and tracing under Section 11. The panel will bring together academics, former SEC officials, including a former SEC commissioner, and practitioners to provide insight into the costs and benefits of our current framework. It will discuss proposed administrative remedies in each area, as well as the viability of these options and potential unintended consequences. But before we turn to the remarks of commissioners, I'd like to note that this will be the final meeting for a number of our IAC members, including Assistant Secretary Brian Helmer and departing members Jamila Abston Mayfield, Cambria Allen Ratzlaff, Sandra Peters, Paul Sommerstad, Alice Steinbach, and Joanne Yu. We thank them all for their invaluable contributions and their dedicated service throughout their tenures. I invite them all to share some remarks, if they wish, after the Commissioner's opening remarks. I would also like to welcome the following new members to the IAC: George Georgiev, Craig Kanoki, Amy McGarity, Jennifer Schultz, Andrea Seidt, and Alvin Velasquez. And now we'll turn to opening remarks from the Chair and Commissioners. First, I'd like to call on Chair Gensler for opening remarks.
Well, good morning. It's good to be with the committee. I always need to note that my views are my own as SEC chair, not speaking on behalf of my fellow commissioners or staff, but that will become apparent when you hear from the other commissioners, of course. I, too, want to thank the committee members. I think it's 7 if I'm not mistaken, who have served so well, but will be leaving the committee in November. We at the commission have really benefited from your insight, and I want to wish you all the best. Welcoming the new members to the committee. Thank each of you for your willingness to serve and provide the commission with important perspectives on behalf of investors. As was said, I understand there's two discussions today, one on the fiduciary obligations, another regarding shareholder proposals and Section 11 claims. I'm just going to sort of go back and think about this, but look forward to your comments. 100 years ago in 1924, so 100 years ago this year, a salesman of pots and pans, Edward Leffler, invented the mutual fund. After the stock market crisis of 29, in the midst of the Great Depression, Congress asked the then newly formed SEC for recommendations dealing with the risk in this new field. We wrote reports in 1940, then SEC Commissioner Robert Healey. You'll later hear from former Commissioner Rob Jackson, but way before Rob Jackson, there was Robert Healey who told Congress that left unchecked, these risks and conflicts had produced a shocking number of abuses. He went on to say, too often investment trusts, investment companies were organized and operated as adjuncts to the business of the supervisors and insiders to advance their personal interest at the expense of and to the detriment of shareholders. And he summed it all up so eloquently when he said, it is perhaps not too much to say the disregard for fiduciary standard lies at the root of many investment company problems. Well, Congress responded, the president responded. We know the 40 Act and the Investment Advisors Act so importantly put in place, but also the Supreme Court by 1963 in a very important seminal case, capital gains research, also spoke to fiduciary duty. So while today's panel is focused on differences between fiduciary duty obligations under federal law and state law, I think there's a common theme across all of these standards. To put it plainly, fiduciary duty comes down to an obligation to put the investor's interest or the interest of clients ahead of the investment advisor. And that's what we're committed to do here at the SEC. I understand your second panel is going to discuss, under Colleen's leadership, discuss shareholder proposals, Section 11 claims. I'm glad that Commissioner Jackson is there too. If he's in the room there, I look forward to seeing you in a few weeks up in New York, Rob. But I think Roosevelt and Congress understood another thing, the importance of aligning the interest of managers with those of shareholders, and they crafted the federal securities laws to have the SEC oversee it. But we were not just a disclosure-based agency. We also had something to do with corporate governance. And when a shareholder buys stock in a public company, they own a piece of that company, which comes with certain rights under state law, rights to elect directors and rights to make proposals for consideration by others. And so Congress included provisions in the laws that shareholders participate in a proxy process. And for decades, there have been debates about this. This is not new in the 2020s. It was going on in the 1960s as well about which shareholder proposals must be included in the proxy for consideration by other shareholders, which can be excluded. In fact, in 1942, the SEC first adopted a version of what now people call Rule 14a-8, and it's been amended from time to time. In essence, it came down to a rule that outlines 13 bases on which companies may exclude shareholder proposals. And I know you'll be discussing this later. With regard to the Section 11 claims, I don't know. I think of it this way. I emphasize that the section's important part of our federal securities law architecture because, in essence, Congress imposed on directors and officers a liability for inaccurate registration statements. And this was actually pretty well debated in 33. It was not just put in by a few staffers. And these gatekeeper provisions help to provide an essential function, that the gatekeepers provide a function to police fraud and ensure accuracy and disclosure. So I look forward to hearing what the panelists have to say, and I thank you.
Thank you, Chair Gensler. Next will be Commissioner Peirce for opening remarks.
Thank you, Brian, and thanks to everyone for being here. We especially welcome our 6 new IAC members. Our new class of members brings a wonderfully eclectic mix of skills and experiences, and we're grateful that you're putting them to use for us here at the Investment Advisory Committee. So welcome Alvin, Andrea, Amy, Craig, George, and Jennifer. And we're also sadly marking the final meeting for 7 sitting members whose terms expire in November. Jamila, Cambria, Brian, Sandy, Paul, Alice, Joanne, thank you all for your work for the committee. I have really enjoyed learning from all of you, and I hope that you will know that you have an open door to come back and talk to me anytime you have input that you're not able to provide on the IAC. We're still very happy to hear from you. Today's agenda, as you heard, consists of 2 panels, and I'm looking forward to the broad discussions that I think will ensue at those panels. As you heard, the first panel relates to fiduciary duty. The Institute for the Fiduciary Standard has labeled September Fiduciary September, so I think your timing is good. But fiduciary is a hot topic all year round, so it would have been good anytime. I do look forward to hearing the panel's views on what this term means in the different contexts that it's used, particularly in the provision of investment advice by SEC-registered investment advisors. As the Commission has explained, when the fiduciary standard applies, we're able to take a principles-based approach to regulation that allows an investment advisor latitude to use her own judgment in meeting the standard. This principles-based approach is at the heart of the Investment Advisors Act. The second panel concerns the relationship between shareholders and public companies with respect to a shareholder's right to sue for a material misstatement or omission in a registration statement. A unanimous Supreme Court has spoken definitively regarding traceability, which is one subject of the panel. So I'm looking forward to hearing your reactions to that Supreme Court case. Shareholder proposals are also very much a live issue, and so I do have a question for your consideration. How do we make sure that the voices of non-proposing shareholders are heard in conversations about shareholder proposal thresholds and other shareholder proposal issues? This group of investors bears the bulk of the cost when companies spend time and management attention to deal with shareholder proposals. Non-proponent shareholders may not enjoy proportionate benefits. The proponent's motivation is sometimes not deriving from her ownership stake in the company, but from a concern that transcends that company, or maybe even is really divorced from that particular company. Thus, the benefits of her engagement with the company may not inure to the benefit of other shareholders. Both panels have participants with a variety of views, and so I'm really looking forward to hearing what all of you have to say. Thank you to Christina and to Danielle and the rest of the dedicated staff in the Office of the Investor Advocate for making today's meeting possible. Thank you.
Thank you, Commissioner Peirce. Next will be Commissioner Crenshaw.
Good morning. Thank you, Brian. First things first, it appears mainly this corner.
That's right.
Is what I'm talking to. I don't want to leave out. I know we got some over there, but really it seems like we're just lopping off. No. So I do want to thank all 7 members who have so ably served the committee over the past years. Jamila, Cambria, Brian, Sandra, there you are, Paul, Alice, and Joanne. I want to just thank you for your hard work, your insights, your diversity of perspective. You've put on thoughtful panels, made recommendations, and published viewpoints on topics ranging from complex products, including single stock and levered ETFs, to crypto assets, to the digital engagement practices, and your input has been invaluable to both the Commission and to me as you've gone about your work. So thank you. Again, mainly this corner, but thank you, Alice. So really appreciate it. And as Commissioner Peirce said, my door is always open for ideas. I look forward to continuing to hear from you. I hope the work does not end today. And next, I would like to welcome the newest members of the committee, which is at least somewhat over on this side. Did we do that on purpose? So thank you in advance, not only for your critical service, but for the enthusiasm, the vigor, the critical thought, and compassion that I know you're going to bring to your new position here. You're tasked with helping us ensure that when investors put their hard-earned money into capital markets, they do so without fear of fraud or wrongdoing, that they're armed with the disclosures they need to make informed investment decisions, that they know the key risks involved in investing, and that market participants bear accountability for their actions. This is no small order. If we do not maintain the integrity of this structure, we will put in peril retirement savings, college savings, small business startup capital, anything that folks have worked hard to put aside for their future goals, for their dreams, for their children. In short, our collective futures and goals. We cannot fail in this mission. So if it's not yet clear, I think you all have a very important role to play. We invite you in this common endeavor to bring your biggest ideas, to present new perspectives, to apply your diligence in pursuit of solving hard, real-world problems. Help us bridge gaps where there may exist and build common ground for new and better regulations. When you speak, we listen. So we hope you will make recommendations to us about rulemakings or other initiatives concerning topics that have become part of the national discourse. And this can range from ideas and concerns that you're seeing in your everyday aspects, or things that we're seeing, or rules that we're contemplating, things from private credit, RIC fees, whistleblower protections, mandatory arbitrations, a whole host of topics. And I think turning from that, with that, just a little bit of responsibility I'm laying on your shoulders today, I want to turn to today's discussions, which I think should be informative and enlightening. This morning, as you've heard, we're joined by an esteemed panel, some of whom I have known for over 20 plus years, 30 plus years at this point, who join us from Minnesota, and look forward to hearing from you all. And you're going to cover, I think, the topography of financial professionals' obligations to their clients, and how this may impact, these differing sort of obligations, may impact investor outcomes. To the extent that there are differences between the standards governing investment professionals under various legal regimes, ERISA, state securities laws, insurance law, that allow for exploitation by wrongdoers and recidivists, I hope you will think broadly about ways to work with us and ways to work with regulators in a way to think creatively about how we can work together as regulators with different responsibilities and different obligations and different statutes, and how we can work together maybe more productively with states than we are, or more productively with the Department of Labor, and potentially legislators if the need arises, to diminish opportunities for regulatory arbitrage. And in the afternoon, the committee will hear presentations about two areas that are critical to a balanced marketplace: corporate democracy and an investor's ability to seek remedy in federal courts. These are core issues that require careful and diligent review by the committee members. And I'm glad to see that the afternoon panel includes, again, another group of just incredibly well-regarded experts in the securities laws. And I urge you all to consider the presentations carefully. The beauty of this committee is that you're able to engage with critical policy topics, weigh the equities, and then advise the commission by writing a recommendation. The public service is invaluable, so thank you for taking the time out of your very busy lives and careers to be a part of it. I appreciate it very much, and I look forward to the discussions today. Thank you.
Thank you again, Chair and Commissioners. Would any of the IAC members whose terms expire later this year like to make a statement? Brian Helmer.
Yeah, I just wanted to say to everybody that it's been a great, opportunity to serve on this committee. I want to thank everybody for all that I learned from you, and all the collaboration we did, and I'm just truly grateful to have been part of a group that is so committed to positive change. And to say welcome to the new members, and I hope you're buckled up for a really meaningful and interesting experience. And I encourage you to bring your energy, your passion, and your ideas to the forefront so that we can continue this important work. So thank you all. I really appreciate it.
Thank you, Brian. Anyone else?
I will.
Sure.
I want
Sandra?
to echo the comments that Brian made. I was thinking about, we started off, it's been what I would call strange and interesting times, right? Because we've spent most of the time on the committee remote, so it's nice to end in person. And sort of our tenure has covered a very interesting time, and from one election sort of to another. So that's been a lot of things as you guys were talking. SPACs came back to me, our accounting recommendation, human capital, a whole variety of things, and it's been great. As Commissioner Persh said, there's been an eclectic mix of skills. I think she said it better than I could say, and great, from my perspective, a great learning of things and topics and things that I've agreed with and disagreed with, and I wish all the new committee members as interesting a tenure as we've had.
Cambria, I saw your hand as well.
Yeah, no, first I want to thank the chair and the commission for the opportunity and for the support for our work, and to the incredible staff, both past and present, who have provided critical support for us. It's been an honor and a privilege to serve alongside my colleagues here, representing the interests of large institutional owners, which are pension funds, benefits trusts, et cetera. Our remit to advocate for investors is a very important one. Many stakeholders in the market already have advocates for them. And really, this is the body that's exclusively for investors, the little guy or lady, to advocate on their behalf because they need the most protection. So I just wanted to just thank you for the opportunity, and maybe a couple words of wisdom that were imparted to me. First, just dive in. 4 years goes by super fast, so don't hesitate. We really need your voice now, and markets are global. So it's so important to maintain the competitiveness of the U.S. markets because we are the deepest, the strongest, the widest pool of capital on Earth. And really, the globe depends on the strength of our markets. So with that, just thank you so much, and good luck to all of you. I know you'll be awesome. So thank you.
Thank you, Cambria. Alice?
I'll share more of my thoughts later. There are a lot of us. So here I will just echo what has been said, and I want to express my gratitude to the Commission and to all of you and the staff of the Commission, past and present, for this opportunity to work with such an amazing group of experts. Your dedication to investors is clear and inspiring, and it was an honor to work alongside you these last 4 years. To the new members, I would say this is one of the most gratifying things that you will do. It is so rewarding to see the Commission respond to the recommendations that we make. I actually saw an investor.gov TV commercial in July and in August, which was very gratifying to see. Don't forget about investor education, but do jump right in and have a wonderful time. It is an amazing experience, and thank you all for that.
Jamila?
So much has been said, and I don't want to, just echo everything. But one, thank you to the chair, to the commissioners. Thank you for having this committee, maintaining it. We feel, as Cambria said, it's critical for the investors, and we're happy to be a part of serving them and making sure they're represented. This has been a real joy to return to the SEC from my examiner days. So 2008 to 2016 was my time, and then getting to come back and serve in this way has been tremendous, and a very different lens after working with the industry very directly, at Ernst & Young. So I am thrilled to be able to turn this over to 6 wonderful folks. We got to meet a lot of folks yesterday at dinner, and this morning. You all are in for a treat. You will be challenged. You will hear differing opinions. Bring your voice, as everyone has said, because it matters. And don't be afraid in this meeting to start bringing your voice forward and asking questions. That was something that was told to me when I joined. There's no time like today to begin to raise your hand and ask questions and be a part. To my fellow leaving folks, we're not going too far, and we've already set up ways we're going to stay in contact. We can always write a letter. We can send a note. You won't lose us, but if you need us, please know, I think I can speak for everyone. You can reach out to us. We're happy to come back and serve on panels and be there for you. So good luck, and thank you, guys.
Jamila, thank you. Anyone else like to say anything? Paul?
Yeah, I'll be very brief, and it's been a privilege and honor to serve in the interest of the American investors and consumers out there. And it's now, I think, over 10 years or so since this committee was formed, and very much appreciative of seeing, as Alice noted, a lot of the great work that this committee has put forth and then seen in action, again, to serve the American investors. So that's been very much appreciated, and we're very confident the new members here will continue to serve and ascend as we go forward.
Paul, thank you. Is there anyone online who'd like to say something? Okay, if not, let's turn to the next item on our agenda. Again, thank you, each of you, for serving. And the next item is going to be approval of the minutes of our June 6, 2024 meeting, which have been circulated prior to the meeting. Do I have a motion to approve those minutes?
Motion to approve.
Thank you. Can I get a second, please?
Second.
Thank you.
Aye.
Aye.
Any objections? Terrific. Now I'd like to turn to our morning panel, Investment Advice, a History and Update on Who is Required to Serve in Your Best Interest, which will be moderated by Paul Summerstad. Paul?
Well, thank you, Brian, and thank you, everybody, for your time today. The goal of this panel is to dive into the various definitions of fiduciary advice for financial professionals and different standards that are out there to help the investing public better understand who is required to act in their best interests when providing investment help. As Chair Gensler mentioned earlier, the mutual fund was created roughly 100 years ago. The SEC, the Securities and Exchange Commission, was created 90 years ago when the Investment Advisors Act of 1940 was the unofficial emergence of the regulation of the financial services industry. And that 1940s act first established the concept, later confirmed in court, that investment advisors have a fiduciary obligation to clients. We have 5 excellent panelists here today. Brian Tiemann, a partner in employee benefits at McDermott, Will & Emery. Dr. Edwin Hugh, associate professor at the University of Virginia School of Law. Allison Itami, a partner at Lathrop GPM. Jason Berkowitz, chief legal and regulatory affairs officer at the Insured Retirement Institute. And Aaron Coppell, managing director, government relations and public policy counsel at the CFP board. Without further ado, I want to hand the floor to Brian Tiemann for his remarks.
Thank you, Paul, and thank you to all the members of the committee. Those of you who are leaving and those of you who are joining, it's a great honor to be here today. As we just celebrated the 50th anniversary of ERISA, which is quite a milestone. It feels even more timely to be here with you talking about many years of work that have gone into multiple proposals to rethink maybe the definition of fiduciary with respect to providing investment advice that's under ERISA, and then the other standards that we see our investment professionals subject to. So it's great to be here to discuss this with you. We start with just a bit of a history, which will be my sections, just to give you sort of a little bit of a groundwork where we've seen the DOL's proposals come to. When we started this conversation, we thought the latest proposal would be well on its way towards taking effect, but as I'm sure all of you know, like that has currently been stayed by some court challenges, which were also not unanticipated. So, but we'll talk through those proposals and give a few highlights before my co-panelists jump in with some more context. The initial regulations that we saw come out on this were issued in 1975, so the first year after ERISA was passed. And those are still the groundwork that are in place today for fiduciaries, given the stay of the most recent 2024 regulations. And so one of the questions I think to think about as we quickly walk through this history is sort of what has been the impetus for needing to reevaluate the effectiveness of these rules. And I think that's really been the evolution of what we see as the market for retirement plans and retirement vehicles. We've moved from back in the mid 70s, a world where everybody participated, primarily in a defined benefit pension plan, into a much different world today where we're thinking 401k, 403b, defined contribution plans, and IRAs. And so our consumer for this investment advice has shifted from employers and from plan governance committees to individuals who are challenged with investing their own investment advice. And it's been that sort of framework that's really been part of the shift in terms of what we've seen the DOL over the past 15 years sort of rethinking what this fiduciary framework is. And I think as we quickly talk about this, some key themes to think about are, right, what are the standards for our investment professionals, and do those standards, are they the same for our registered investment advisors who have more of a relationship role versus our broker dealers who are more of transactional based? And then also thinking about what is the scope of fiduciary duties to those that are providing advice to IRA owners, so with respect to IRAs, which has typically been carved out of ERISA, despite the DOL's more recent attempts to expand that into there. So under the 1975 regulations, so the rules that are in effect today, we have a 5-part test that talks about who is a fiduciary under ERISA with respect to providing investment advice. And that really comes down to somebody that's rendering advice or making a recommendation on a regular basis, and that's going to be an important distinction here. Pursuant to a mutual agreement with a plan or a plan fiduciary, that their advice will serve as the primary basis for investment decisions, and that advice will be individualized to the needs of the plan. That's been the rule that was set forth in 75, continues to be in effect. We did see the DOL many years later in 2005 issue an advisory opinion, and this was the first step towards thinking about whether advice to a retirement plan participant on whether they should take their money out of their plan and roll it over into an IRA, is that rollover advice subject to the fiduciary rule? And back in 2005, this advisory opinion found that rollover advice that was coming from an individual or an entity that was already a plan fiduciary would be a fiduciary act, but that advice coming from others would not be subject to the fiduciary standards. We're going to see them revisit that. The next set of standards, we saw in 2010 some proposed regulations come out from the DOL. And again, they were sort of revisiting this 5-part test, and they found that this shift from defined benefit to defined contribution plans had some problematic components when we think about the relationship that an individual versus an employer or governance committee might have. And these are the sort of the regular basis component of the definition, this mutual agreement piece of it, and then that their advice would be serving as a primary basis. So those 3 components of the definition the DOL was concerned could be problematic. And they issued proposed regulations with a new definition of who would be a fiduciary under this that more or less took out those 3 components, thinking that an individual might not have that regular basis with an ongoing advisor and might not have the mutual understanding, but should still have the protections of a fiduciary rule. They also attempted at that point to include the proposed regulations that these fiduciary standards would also apply to IRA owners. So the advice that they're receiving would also be part of that. The regulations included some specifics that I detailed on the slides that you can reference in terms of what advice would be subject to the rule and what advice would be excluded from the rule. So it was an attempt to be helpful there. very controversial, right? So when the DL issued these proposed regulations, there were hundreds of comment letters. There was a 2-day public hearing, and then after the public hearing, there was an additional flurry of comment letters, and that prompted the DOL to sort of take a step back and say that they would be reevaluating the regulations and coming up with a different proposal in mind of all the comments that they received. And we saw that come out initially in the form of proposed regulations in 2015 and then actual final regulations in 2016. And this framework sort of built on what we saw out of the 2020 or the 2010 rules, but addressed some of the comments that they received, and then also were coupled with a number of new prohibited transaction class exemptions, as well as amendments to several other exemptions. And what these exemptions were put in place was that as we expand who's going to be subject to the fiduciary standard under the new rule from the 2016 regulations, we had to provide some exemptions to allow compensation arrangements that these advisors might have to not constitute prohibited transactions, which are set forth under ERISA. And so we saw the best interest contract, or BIC, exemption come out. That set forth certain standards for advisors to continue their current compensation practices, as well as a class exemption for certain transactions between investment advice fiduciaries and plans and IRAs. The 2016 regulations set forth basically an expanded fiduciary definition that were subject to certain carve-outs, as I noted, for certain conduct that are non-fiduciary in nature. The fiduciary rule at this point, again, no longer required that the advice be provided on a regular basis, and it took out that mutual agreement and that primary basis. So the same thing that we saw, those components that were pulled out from the 2010 definition were also not part of the 2016 definition. So that reflected what we saw as the DOL's concern about trying to make sure that advice that was going to individuals was reflective of who was going to be subject to that rule. We also saw them formalize the piece about rollover recommendations, so that advisors who were giving rollover recommendations participants were subject to the fiduciary standards under the 2016 regulations. And notably, the 2016 regulations and also formalized that the fiduciary standards would extend to advisors for IRA owners for the first time, and no longer would IRA owners be subject just to the parallel restrictions under the Internal Revenue Code. The 2016 regulations were challenged. Again, there was a sort of a bit of a history. We had a change in presidential administration that led to the White House asking the DOL to sort of reconsider the rules and whether they were, effective and did not have an impact on consumer choice or access to information or financial advice. We saw the DOL issue some delays, and then ultimately we saw a ruling from the Fifth Circuit that vacated the rule. And the rationale for the Fifth Circuit ruling was effectively sort of two-part. One was that the DOL exceeded its authority in issuing these regulations, and that expansion of these obligations should have been an act of Congress versus an act of the DOL. And one notable part of this was thinking about that the IRA, IRAs had always been subject to parallel rules under the Internal Revenue Code and not ERISA, and that was beyond the DOL's authority to sort of make that extension. And then the courts also found that the DOL had expanded the definition to a basis that was not a reasonable interpretation of the statute, and that they had taken it too broadly, specifically including a private right of action under the BIC exemption, the best interest contract exemption, that again was not set forth in ERISA, so was an unfair or expansion of that rule outside of their authority. So that was sort of the end of what we saw with the 2016 regulations, which led us to the most recent set of regulations as we parse through this history, which were proposed in 2023 and then finalized in 2024. These are referred to as the Retirement Security Rule. And again, so we see the 2024 regulations largely building on the 2016 regulations. and also accompanied with several new with several amendments to prohibited transaction exemptions. Specifically, one exemption that permits parties who are already providing investment advice to receive reasonable compensation in exchange for their services, which allows for receipt of commissions and third-party compensation, provided various requirements are met. And then the other piece, which allows for the purchase of advice related to insurance contracts and annuities, which we're going to talk about a bit more by one of our other panelists. The 2024 regulations sought to do was basically define an investment advisor, the fiduciary standard for investment advisors in this context, as to anyone who's really recommending an investment transaction or a securities transaction for which they receive a fee, and they're providing investment advice to investors as a regular part of their business, and that it's individualized advice, or that the advisor is acknowledging that they're acting as a fiduciary capacity with respect to that. And when we think about revisiting that rollover question under the 2024 regulations, again, we see that rollover advice, even if it's a one-time advice, would be a fiduciary act under the 2024 regulations. The regulations were supposed to take effect in September 23rd, so just a few days was the initial effective date. But as I'm sure you know, the district courts in Texas have considered two cases challenging these, both of which largely set forth that the 2024 regulations violated the rulings on the 2016 regulations, where the DOL was acting outside of its authority in setting forth these regulations. So where we are today, we're still under that five-part test from 1975 while we watch this litigation work its way through the courts, which will take several years likely to do so. The DOL's deadline, I think, is very quickly upcoming. When we think about this in contrast to where we see with the fiduciary standards set forth under the Advisors Act, and certainly with respect to Reg Best Interest, which came out in 2019, we've seen harmonization over time between the DOL and the SEC's own regulatory activity. I think Reg BI was seen as pulling some of the key concepts from the 2016 regulations as part of that rule. And then we saw the DOL further build on that when they issued the 2024 regulations. We've seen, helpfully, in a good way, we've seen some common definitions be pulled out of that. We've seen, so terminology is similar. We've seen, consistent standards and requirements under both the DOL and the Reg BI rules. And then we saw the DOL sort of issue an exemption that also sort of pulled in a lot of the terminology and concepts of Reg BI. So I think as we're watching these challenges, we're getting closer to a place where there's consistent rules for all of our investment professionals.
Well, thank you, Brian, for that kind of history and walkthrough. As investors, is there a place that they can go to kind of better understand whether their financial professional is obligated to act in their best interest today?
Yeah, the best way is really to ask, and I think is the best source of advice, but also checking credentials, in terms of that, looking at disclosures, the rules that we've seen from the DOL, the SEC, even the state fiduciary standards are all seeking to have proper disclosures around this. So looking at those, reviewing fee structures, looking for fee structures that are looking to avoid conflicts of interest, and then also seeking referrals from other clients of those investment advisors. I think the key here is making sure that individuals are informed enough to know to ask those questions. To then, I think the information is there.
Excellent. Thank you. Dr. Hu?
Thanks, Paul. So, hi everyone, I'm Eddie. I'm Associate Professor of Law at University of Virginia. And before joining UVA, I actually worked at the Commission as an economist and senior advisor, so it's a delight to be back to present on this important topic today. And so, Brian did a great job of explaining some of the history of the law in this space, so I'll try and focus a little bit on the law and economics of this area and talk about some of the potential regulatory gaps. Do we have the slides? Okay. Next slide, please. So there are three main things that I want to focus on today. So first of all, financial advisors in the United States can be regulated under multiple jurisdictions, which creates potential for both investor confusion but also regulatory arbitrage. And these problems are more than theoretical, but are the focus of significant government and academic work, to which I've contributed a little bit. Second, despite recent efforts to identify and close these regulatory gaps, there remain significant challenges to improving investor understanding and also investor protection more generally. And third, recent data and trends suggest that one area which deserves greater attention is the sale of annuities to IRA investors during rollover transactions. This is an important and rapidly growing part of retirement planning generally and deserves better oversight, transparency, and regulatory coordination. And if I have time, I'll talk a little bit about my work with IAC member Colleen Honigsberg and former Commissioner Robert Jackson in this area. But in short, we identify state insurance sales as an area that appears to have fairly weak oversight and which attracts high-risk brokers that leave or are forced out of the securities industry. Next slide. So Brian has already covered some of the regulatory regimes, so I'll be quick here. You can think of this slide as basically ordering the various regimes of financial advice in terms of how stringent they are. So at the top, we have the ERISA fiduciary standard, but we also have a subset of IRA fiduciaries who are subject to parallel regulations under the Internal Revenue Code, but in some ways have less protections than investors would have dealing with ERISA fiduciaries. Most of you here are probably familiar with the investment advisory and broker regime, so I won't go too much into that, but just know that there's also a state regulatory regime for small and mid-sized investment advisors. There are, of course, economic differences. Investment advisors tend to provide ongoing financial planning and are paid fees based on assets under management, whereas brokers tend to get paid commissions on a per transaction basis. But one regime that hasn't received as much attention, especially in academic work, is the regime for insurance producers, which is largely state regulated and is increasingly important as insurance salespeople provide retirement advice in the form of selling annuities products. And these are largely regulated under state suitability and best interest standards, which I put in quotes because although they use similar language to regulations like regulation best interest, they have very important exceptions, like, for example, not treating commissions as creating potential conflicts of interest, which in theory would allow insurance salespeople to sell more expensive products that sell products that pay them a higher commission that may not be as good for investors. And so one thing that I want to highlight today is basically the increasing importance of the state-registered insurance regime, and to basically raise the question of whether the standard of conduct that these individuals are held to meets the economic significance of this area. So I'll do that in hopefully 3 slides. Next slide. Okay, so I want to highlight 3 mega trends in the industry. This slide here actually comes from a paper co-authored with Colleen and Rob, and it shows the number of new registrations per year across 4 different regulatory regimes. So the 2 largest regimes in terms of adding new registrations of financial advisors are actually the state insurance regime and the securities broker regime, which we call FINRA brokers. And what's remarkable about this figure is that while securities brokers occupy a much larger mind share in both regulatory discussions and popular culture, the number of people signing up each year to be brokers is actually slightly in decline. By contrast, there's been an explosion in registrations among insurance producers, with nearly 1 million people signing up in any given year in recent years. Of course, many of these might be folks registering to sell traditional insurance products other than annuities, but recent numbers show that annuities now represent the majority of premiums in the life insurance space. Next slide, please. And among annuity sales, a major trend is the rise of fixed index annuities, which, like index funds, have payouts that vary based on the value of a basket of securities. There may be floors or ceilings, but these products essentially require investors or consumers to take on some investment risk. But unlike variable annuities, which don't have a floor or ceiling, these are not regulated under the securities regime, but are instead regulated under the state insurance regime. And the fixed annuity market in general has seen a significant surge in sales since the financial crisis, with significant growth coming from the fixed indexed market. And it's also the case that fixed index annuities are increasingly being sold by independent producers. Those are individuals who are not formally employed by insurance companies, but who sell insurance products on a contractual basis. And in fact, in 2023, the majority of index annuity sales came from independent channels. Next slide, please. So the final trend that I want to highlight is something that Brian hinted towards earlier, and that's basically the overtaking of 401k assets by IRA assets. So this is also a relatively new phenomenon and is largely due to rollovers, such as when individuals retire and move assets out of their employer-sponsored plan and into an individual retirement account. And when that happens, they largely assume responsibility for managing their own retirement assets, but perhaps they'll work with a financial professional of some form, but these individuals may not have the same strict fiduciary duties as an ERISA fiduciary. And today there are nearly $14 trillion in IRA accounts compared to only around $10 trillion in 401k accounts, according to recent data from the Investment Company Institute. And that makes the IRA market arguably the most important market for retirement advice. Next slide, please. So what does this all mean? Well, today, more and more retirement advice comes from state-regulated insurance producers. A large portion of these sales are in the form of fixed index annuities, which are potentially very useful for retirement savers, but also difficult for investors to understand in terms of their structures, their fees, and potential penalties. Moreover, a lot of advice is happening in the IRA rollover context, where responsibility for investment decisions shifts to the individual and where financial advice can be particularly helpful or particularly harmful if conflicted. How am I doing on time?
You're good. Yep.
Okay. So how big of a problem is this really? Well, it turns out that there's quite a bit of research in the academic literature about brokers and their incentives, which can be, fairly similar to those of insurance producers. From the economics literature, we know that brokers tend to steer clients towards more expensive and worse performing financial products, and they also seem to provide worse advice to less sophisticated consumers. Next slide, please. In the solution space, there's some evidence that at the federal and state level, fiduciary duties could improve outcomes for investors. One paper that's gotten a lot of attention is the paper by Bhattacharya et al., which is often cited for the idea that these heightened obligations can reduce access to financial advice. But I should point out that the authors are very clear that this only seems to reduce access to the worst type of financial advice. So on net, it may be the case that these benefits outweigh the costs. Unfortunately, as I pointed out at the top, the regulation of financial advice is quite fragmented. Recent research shows that when Congress shifted oversight of small and mid-sized advisors to the states, investor complaints went up. And in recent work with Colleen and Rob, we show that former brokers with a history of harming investors systematically leave the securities industry, but continue providing financial advice as state-regulated insurance producers. And this migration tends to be more common in states with less resources for insurance oversight. Outside of academia, next slide, the government has also done quite a number of important studies in this space, identifying regulatory gaps. For example, in 2008, the SEC hired RAND to conduct surveys of investors and found that even supposedly sophisticated investors did not understand the regulatory distinctions between brokers and investment advisors. And the White House and the GAO have also done many studies across different administrations, highlighting the costs of conflicted advice, and in particular, the gap between 401k and IRA markets. The most recent GAO report is actually quite interesting because they essentially sent out secret shoppers to talk to different financial advisors and found that even financial advisors are struggling to explain regulatory distinctions to their clients. So talk a little bit about my recent work if we have time.
Yeah, about 3 minutes.
Okay, perfect. So as I mentioned before, I have some work with Colleen and Rob. In particular, this is our most recent paper, Regulatory Leakage Among Financial Advisors, Evidence from FINRA Regulation of Bad Brokers. And next slide, please. I'll try to be brief here. But basically what we did in the paper is we gathered information on the registration of different financial advisors across regulatory regimes. We gathered comprehensive data on broker and advisor registration information from FINRA's Broker Check and the SEC's IAPD database, but we also gathered registration information through public records requests made to all the states, which covered roughly 2.3 million insurance producers. Next slide. What we found in this paper is that brokers with a history of serious misconduct were significantly more likely to drop their securities license if they were already registered to sell insurance products at the state level. And they were more likely to do so if they lived in states with less resources for overseeing insurance producers and where they are potentially able to make more money as insurance producers compared to being securities brokers. But probably our most interesting finding is that when FINRA attempted to discipline bad brokers in recent years by raising the cost of employing them, these bad brokers left the industry, but 98% of them remain in the financial advice business by staying in insurance. Next slide, please. So this figure here basically just shows the flow of former FINRA brokers. There are thousands of them that leave in any given year. But what's interesting is that among the smaller subset that have what we call serious misconduct, basically a history of harming investors and where regulators have taken action, the vast majority of them end up in the same place, which is the insurance regime. It's very rare to see a former bad broker end up as an investment advisor or, either on the state or on the SEC regulated side, and that makes sense given the significant scrutiny in those regimes. Next slide, please. And what's interesting about this pattern is that the brokers that leave the securities industry tend to have more instances of harming investors in the past, both, as recidivists or, just having one instance of harming investors. Next slide. And what we found most recently is that the vast majority of these former brokers are currently licensed to sell annuities products. I think something like 93% of them are still licensed to sell annuities. In theory, they can't sell variable annuities anymore without their securities license, but they can sell very similar products in the fixed indexed annuities space. Next slide. And this result is figure is a little bit technical, but basically what it shows is the likelihood that any given broker with a history of misconduct might drop out of the securities regime. And the dotted line shows when FINRA basically started scrutinizing a certain subset of these repeat offenders. And what we found is that these brokers were significantly more likely to leave in the immediate years after FINRA began scrutinizing them, compared to very similar brokers that work basically at the same firm who have similar levels of experience and similar levels of conduct. And all of these folks, I think 98% we show in the paper, are still licensed to sell insurance products. Next slide, please. So I'll just skip this one. Next slide. So in sum, based on that paper and other work, it seems like there could be greater regulatory coordination and accountability, in particular in overseeing the folks that leave the securities industry but continue providing financial advice. One way that coordination can be improved and investor education can also be improved is by providing a single unified database for all licensed financial advice. Academic work has shown that if investors could avoid dealing with the 5% worst financial advisors in the industry, they could avoid something like 29% of all fraud cases and 40% of all dollar losses. But based on our experience in trying to assemble this data for the insurance side, that's pretty much impossible. Finally, insurance regulation can borrow a bit from its securities regulation. In particular, we think that policymakers could incentivize insurance firms to better monitor and discipline their agents, and in particular, independents. And that's something that the DOL tried to do in some of its recent rulemaking, which I found to be very interesting. So next slide, please. In conclusion, there have been a lot of recent regulatory efforts to close important gaps, but there's several important challenges. In particular, there's very limited insight into financial advice in the insurance industry. And even though the insurance regulators have proposed and adopted a new best interest standard, there are important gaps. In particular, unlike all of the other financial advisory regimes, compensation is not treated as creating potential conflicts of interest, but as an economist, that's like a pretty obvious omission. And also currently there's very few protections for the increasingly important IRA market. And so hopefully policymakers can work to think about what to do in this space. Thank you.
Thank you for your remarks, Eddie, and I'll hand the floor to Allie.
Thank you. Hi, I'm Allie Atami. I am a partner at Lathrop GPM. I've been an ERISA attorney for 15 years. A majority of those years I've been here in DC, but this is actually the first time that I've made it through security into the SEC's building, and I'm hoping that I can take you sort of on a virtual field trip back into my world at the DOL. I'd like to address why these rulemakings, the 2024 rulemaking and the 2016 rulemaking, have been controversial. So I'd like to address what the impact of being an ERISA fiduciary truly is. After all, isn't acting in the best interest of the investor sort of a no-brainer? Isn't that laudable? Why is there any pushback at all? And I'll hopefully set up why there is some pushback, and I know that Aaron and Jason are going to sort of build on that as well. Much of the controversy, in my opinion, can be summarized into whether the DOL can legally promulgate the standard that it has, and then whether, as a policy matter, it should. Whether there are potential negative consequences that result from this that are not wanted. So critics of the rule have taken the position that the 2024 rulemaking, along with its 2016 predecessor, impose a fiduciary standard on sales relationships that are not ones built on trust and confidence. And if the scope of the 2024 rule is broader than relationships of trust and confidence, it presents a legal question. Can DOL regulate those types of relationships, or must Congress actually act in this instance? And this is where you'll hear a lot of legal scholars talk about the Administrative Procedures Act, deference, and the recent Supreme Court case in Loper-Bright. As Brian mentioned, the district courts in Texas have issued 2 stays based on their findings that the DOL's 2024 regulation is likely excessive. It exceeds the trust and confidence standard and is beyond the DOL's rulemaking authority. Supporters of the rule, on the other hand, I'd say that the DOL can, in fact, act in this area. They argue that financial professionals have indeed, in this day and age, really created a perception of trust and confidence within the retail investing public when they make individualized recommendations. And that would mean that the 2024 rulemaking is not in excess of DOL's authority. So in addition to the can DOL legally promulgate this rule, there's sort of questions about whether they should. The newest efforts are open to criticism that over the past 16-ish years, a number of other regulatory regimes have come into play that have potentially closed the gaps that are missed by ERISA 321's definition of fiduciary. And those regulatory regimes, I think, have been mentioned by some of the other panelists. Regulation best interest, NIAC's Model 275, New York's best interest standard for annuity sales, and a variety of other items that, as Chair Gensler mentioned at the top, all coalesce around the idea of putting the retirement, sorry, you can tell I'm an ERISA attorney, not always the retirement investor, putting the investor's interests above that of the person giving the advice. So, given that nobody here, to my knowledge, actually sits on the federal bench in Texas, we will leave aside the legal question of can the DOL act here and touch on sort of the questions about should they act. And that really goes to the potential consequences of being an ERISA fiduciary. I'd like to give you some basis for you to think about whether or not being inclusive or perhaps overly inclusive in the definition is the right policy move. So if we skip ahead to the next slide, I'll touch quickly, one back, on what it means to be an ERISA fiduciary. When you're an ERISA fiduciary, you're subject to a standard of care. That means you must act solely in the interests of the participants and beneficiaries for the exclusive purpose of providing benefits with the care, skill, prudence, and diligence under the circumstances that a prudent man, this is a mouthful, in similar circumstances with like aims would provide. So again, the Dutch points there are really the prudence and loyalty standards. In addition, there's a private right of action for breach of fiduciary duty claims. ERISA Section 409 provides for personal liability when the ERISA fiduciary has breached those duties, and then there can be additional penalties under ERISA Section 502. So why not just act in the customer's best interest and move on? If it's that easy, why are we here having any sort of controversy? And that's really where prohibited transactions come in. So if we move on to the next slide, ERISA is really a statute of prohibitions. Many essential actions, in fact, almost all essential actions having to do with an IRA or a retirement plan cannot occur unless there is an exemption. That is, ERISA is a statute of no unless you've met the conditions for an exemption. There's even specifically a set of transactions that a fiduciary cannot do. And I've listed those on the slide, but I won't make you read them. I will summarize it as essentially saying that a fiduciary cannot act in a manner that causes him or herself to be paid additional compensation, whether that's a fee, a commission, additional asset management fees to their employer, or a higher managed account fee. And the framing is really important here. It's not a prohibition on recommending an investment that is better for the recommending person and worse for the investor. It's a prohibition on a recommendation that benefits the recommending person at all, even if you can conclusively say that recommendation is in the best interest of the advice recipient. It does not matter under the prohibited transactions whether or not it's in the investor's best interest. That only matters for the next step, and that is compliance with an exemption. So if we move to the next slide, there are prohibited transaction exemptions that exist that allow folks like investment fiduciaries to provide advice for a fee. There are both statutory exemptions and administrative exemptions. The statutory exemptions don't comprehensively cover the self-dealing conflicts in the provision of investment advice. So we end up looking to administrative exemptions. And these administrative exemptions are promulgated by the Department of Labor, and the Department of Labor has a lot of discretion in what conditions they can put into these exemptions. And that has really created some instability in the marketplace. The exemptions under ERISA are usually titled with the year they were issued. So PTE 77-4 came out in 1977 and addresses the use of mutual funds. Obviously, that has been around for decades, and these latest rounds of fiduciary rulemaking have changed them. So companies have compliance regimes built around these decades-old exemptions that now get thrown out. So this type of instability is not welcome. And why are prohibited transactions and their exemptions so important? And I think the real crux of the controversy comes down to excise taxes. If you enter into a prohibited transaction, you are subject to a self-imposing excise tax of 15% of the amount involved. This can escalate up to 100% of the amount involved. And this, like I said, is self-imposing. This happens whether or not the investor has any damage. If you have tripped over that prohibited transaction line, you're subject to this tax. And interestingly, in the latest administrative exemptions like the BIC and like PTE 2020-02, by putting a fiduciary standard into an exemption, there is now an excise tax possibility for a failure to have met the standard of care. That's not how Congress set it up. Congress set up ERISA so that 409 was the potential for damages there, and not an excise tax that potentially, just spirals and spirals and spirals. And so that is really the crux of where a number of folks have problems with the way that the definition and the exemptions play together. So if we move to the next slide, just touch a little bit on the PTE 2020-02 that I mentioned. This is the exemption that allows folks to get compensated while providing investment advice. And for the most part, there's actually quite a bit of overlap with regulation best interest. There was a very big attempt at harmonization, and both regimes look at having a standard of care, loyalty, some disclosures, some record keeping, and as I mentioned, and as Chair Gensler mentioned, really focus on not placing one's own financial interests ahead of the recipient's interests. Which is great if you're already subject to Reg BI, but not everyone is. So ERISA's scope is in some ways broader, in some ways not as broad, because obviously it does focus on retirement investors, but it covers retirement plans, which regulation best interest does not. It covers VEBAs, it covers plan asset funds, and it also covers, beyond just who it covers things like implied rollovers, which really limits the ability of two people to say, I'm giving you this advice, but not that advice. And so that has really caused some problems. because when you're in ERISA fiduciary status and have to comply with an exemption, that comes with a lot of direct costs. There are costs to build out all of these compliance systems. There are costs to perform the annual audits. There are costs to filings. They're costs. And then I'll circle back to the excise tax fear. I mean, the fear of a footfall causing these escalating costs is, not one to be diminished. It's a very big motivating factor. And when you have this excise tax fear really being laid over the standard of care that already has the 409 penalties, it gets to be quite a bit. So when all of these potential for instability, for costs, for other items are all added together, you have folks who are thinking it's better for me to just exit the market. So we saw that a little bit in 2016, although the rules in 2016 never fully got implemented. So I'm not sure we saw the full impact of that. And then obviously Reg BI came after that. So the landscape has shifted a bit. But whether, these rules ever go into effect, as they actually are stayed at the moment, and whether or not, if they are in effect, it actually causes financial professionals to leave the market or only service higher account balances, or in fact just increases the cost of receiving advice, questions that are better left to somebody besides a lawyer. And with that, I will let some of those people speak.
Thank you very much, Allie. Jason?
Thank you, Paul, and good morning, everyone. My name is Jason Berkowitz. I am the Chief Legal and Regulatory Affairs Officer for the Insured Retirement Institute. We're the leading association for the entire supply chain of insured retirement strategies, including amongst our members life insurers, asset managers, broker-dealers, banks, marketing organizations, law firms, and solution providers. Thank you for the opportunity to participate in today's meeting. In the interest of transparency, please note that IRI is among the plaintiffs in the litigation challenging the DOL's so-called retirement security rule. As this is active litigation, I will not be discussing the case in my prepared remarks, nor will I be able to respond to any questions about the case. I am here to share our perspectives on the subject of today's meeting, who is required to serve in your best interest, but in so doing, I will also explain why we are so strongly opposed to what the DOL has put out. Over the past 14 years, federal and state policymakers have been working to formulate appropriate standards of conduct for financial professionals who provide personalized advice about investments and insurance products to retail consumers. As we've engaged with policymakers throughout this time, we've been guided by 4 key principles. First, consumers should be able to trust that their financial professionals are acting in their best interest, and the vast majority already live up to this standard. Second, regulators should have the tools they need to protect consumers and appropriately address the conduct of bad actors. Third, if there is evidence that bad actors are exploiting gaps in the regulatory framework as it exists today to harm consumers, those gaps should be appropriately addressed through targeted rulemaking. And last, but certainly not least, consumers must have the ability to access protected lifetime income products and professional guidance to help them acquire and use those products to manage the risks they face as they prepare for retirement. In our view, the rules governing the conduct of financial professionals must effectively and appropriately balance these important principles. We were proud to support adoption of Reg BI and the corresponding best interest model adopted by the NAIC because those rules successfully strike that balance. Our industry is full of good, honest, and hardworking financial professionals who are committed to acting in their clients' best interest and work tirelessly every day to live up to that standard. They help clients understand and navigate the many risks they face in their pursuit of financial security, including the risk of running out of money in retirement, an all too real risk that has ruined the golden years of far too many Americans. Protected lifetime income products help savers manage this risk, and professional guidance helps them acquire and use those products appropriately. Congress recognized this when it enacted the bipartisan Secure Act and Secure 2.0 to strengthen our retirement system by expanding access to these valuable products. And the SEC and NAIC recognized this when they adopted best interest rules that effectively protect consumers without putting unnecessary roadblocks between them and the products and services they need. The NAIC model, which has been adopted now in 46 states and counting, was developed through an open, inclusive, and thoughtful process and reflects the consensus of our nation's top experts on insurance regulation. Consistent with Reg BI, it imposes a strong but fair and workable best interest standard with effective disclosure, conflict of interest, supervision, and training requirements. The DOL says the NAIC model doesn't go far enough to protect consumers, but this is a misguided view based on several significant misconceptions, including the false notion that the model is deficient because it A, does not impose a quote-unquote fiduciary standard, B, excludes cash and non-cash compensation from the definition of material conflict of interest, and C, does not include best interest language in the underlying component obligations. But let me rectify some of these misconceptions. The NAIC specifically chose not to impose fiduciary status, recognizing that state law also imposes fiduciary obligations, many of which are not appropriate or necessary to protect consumers in the context of insurance recommendations. They instead incorporated the concepts of a fiduciary without going so far as to use that label. They also excluded compensation from the definition of material conflicts, not because compensation cannot be a conflict, but because compensation in and of itself is not a conflict. And compensation-related conflicts are best addressed through disclosure. The simple fact that someone gets paid does not automatically mean that they are every advice they provide is conflicted. So that is what they were trying to get to. Could they have potentially drafted it a little bit more artfully? Perhaps. But I can tell you, having sat around the table with them when they were developing this and having spent many years throughout my career working closely with the people who were responsible for developing and enforcing this, they would never, ever, no member of the NAIC would ever say, we are not going to protect the consumer when there is a compensation-related conflict because it is, quote unquote, not included in the definition. So I assure you that that is a misconception, and if there were opportunities for you to speak with the NAIC members and their staff and their leadership, they would tell you the same thing. Finally, they did not restate the best interest standard in the component obligations, which I know in Reg BI is included. And the reason that they chose not to do that was for fear of creating circular definitions. They looked at it as saying, if we're going to impose a best interest standard and then identify 4 things underneath that constitute acting in the client's best interest, if we define those components as requiring best interest, then what kind of guidance does that provide to insurance producers as they're trying to figure out how to comply? You're telling them you have to act in your client's best interest, which means you have to do these 4 things, and to do those 4 things, you have to act in your client's best interest. It doesn't tell them anything. So we tried to explain this to DOL, as did the NAIC and its members, but the DOL opted instead to unfairly malign and disregard this robust state regulatory system. Reasonable minds may disagree with the NAIC's approach, but the DOL is not the ultimate arbiter of the effectiveness of rules adopted by other regulators and cannot merely ignore Congress's explicit recognition of the primacy of state insurance regulation. With Reg BI and the NAIC model in place, the DOL's rule is a solution in search of a problem. The DOL treats the fiduciary standard as some sort of panacea, as if consumers can only be protected if all financial professionals are held to that standard. This is not reality. We cannot wrap a person with bad intentions in fiduciary robes and expect them to suddenly be transformed into a beacon of truth and honesty. Let's not forget, Bernie Madoff was a fiduciary. As the Federal Appeals Court recognized when it rejected the 2016 rule, fiduciary status should only apply when there is a special relationship of trust and confidence. The DOL has tried to circumvent that decision by asserting that such a relationship exists whenever a financial professional makes a recommendation to a retirement saver. We disagree. A special relationship of trust and confidence cannot spring into existence spontaneously. It must be intentionally and thoughtfully cultivated over time. The DOL's rule blatantly ignores this reality. Under the 2024 rule, we believe millions of low and middle income workers, especially those most impacted by the wealth gap, would once again lose access to products and services that can help them achieve a secure and dignified retirement. This is not academic speculation or hyperbole. This is based on real-world experience when the 2016 rule was partially in effect. Deloitte conducted a study in 2016 that found that 53% of firms limited or eliminated access to brokerage advice for smaller retirement accounts in response to that rule, causing more than 10 million Americans with a collective $900 billion in retirement savings to lose access to products and services. More recently, a 2023 study conducted by Quantria Strategies found that reinstating anything similar to the 2016 rule would cause the accumulated retirement savings of 2.7 million individuals with incomes under $100,000 to plummet by approximately $140 billion over 10 years. The DOL's 2024 rule is functionally equivalent to that now vacated 2016 rule, and like that rule, will foster not retirement security, but widespread retirement insecurity. The DOL and its supporters have simply disregarded this inconvenient data, made no meaningful effort of their own to assess how this rule might negatively impact consumer access to much-needed products and services, or even to consider the value of those products and services. Instead, they simply assert, without any current real-world evidence, that this rule is necessary based on hypothetical gaps in the current regulatory framework being exploited to potentially harm consumers. They rely on obsolete studies conducted before Reg BI and the NAIC model were adopted, including a very misleading and unsubstantiated report issued in 2015 by the CEA. Their conclusion was not based on in-depth economic analysis, but on faulty assumptions, including the notion that all advice provided to IRA owners is conflicted. I encourage you to read the detailed critique of the CEA's analysis, which was co-authored by Commissioner Peirce when she was at the Mercatus Center at George Mason University back in 2017 before she joined the Commission. She explains it in a much more eloquent way than I ever could dream of. That brings me back to one of the key principles that I mentioned a few minutes ago. If there were evidence that bad actors are exploiting regulatory gaps to harm consumers in the real world today, those gaps should absolutely be addressed through targeted rulemaking. But a targeted approach is impossible without clear evidence of a problem. So instead, the department adopted a rule that completely upends the existing regulatory framework. They rolled out their PR experts to brand it as the retirement security rule, characterized it as a best interest regulation. They asserted that anyone complying with Reg BI should have no problem operating under this rule. This is not true. Under ERISA, DOL can only regulate the conduct of those who trigger fiduciary status. So the rule would shoehorn nearly all financial professionals into that status to give the DOL jurisdiction. But as Ali explained, ERISA fiduciaries must act solely in the interest of plan participants and beneficiaries. Acting in the client's best interest is part of that. It is necessary, but it is not sufficient to meet this standard. In fact, it requires a complete disregard of any financial interest of the fiduciary or its affiliates. This is incompatible with the commission-based business models where financial professionals are paid by commission and their ability to earn a living is inextricably tied to the completion of recommended transactions. They rely on sales to generate enough revenue to cover their costs and earn enough to stay in business so they can support their families and continue to provide valuable services to consumers. To ensure compliance with the DOL rule, if it were going to go into effect, many financial professionals would have to convert to a fee-based model, which tends to be more expensive than commission-based services over time and is commonly only available to clients with six-figure nest eggs. Clients with less money would be out of luck. The National Association of Insurance and Financial Advisors conducted a survey that backs this up. They surveyed their members and found that only 30% have a minimum asset requirement today. But more than double, 72%, would establish that sort of requirement if this rule were to go into effect. That would cause millions of consumers across America who currently work with commission-based financial professionals who do not want or need fiduciary services, but nevertheless, they would be left without the support they need to prepare for retirement under the DOL rule. Fortunately, this catastrophic outcome can be avoided. Reg BI and the NAIC model prove that consumers can be protected by a robust best interest standard without depriving consumers of access to the products and services they need and want. I'll stop there. Happy to answer any questions. Thank you again for the opportunity to be here.
You're welcome, and thank you very much for your remarks, Jason. And a quick FYI to the IAC, please think through your questions. We're going to have Erin provide her prepared remarks, and then when we're done, we'll open it up to the IAC for questions. Erin, the floor is yours.
Great. Thank you very much. It's a great honor to be here in this room with so many folks who are focused on protecting investors. So thank you for the opportunity to be here. I am the Managing Director of Government Relations and Public Policy Council at CFP Board. CFP Board is the professional body for personal financial planners in the United States. CFP Board consists of 2 affiliated organizations focused on advancing the financial planning profession for the benefit of the public, including administering the prestigious Certified Financial Planner designation, which is widely recognized by the public, advisors, and firms as the standard for financial planners. Today, there are almost 102,000 certified financial planners, or more than 1/3 of all retail financial advisors in America, all of whom were granted certification only after passing CFP Board's rigorous exam that covers a range of financial planning topics and meeting education, experience, and ethical standards. All CFP professionals voluntarily make an ongoing commitment to CFP Board as part of their certification to abide by high standards of competency and ethics, the most significant of which is the requirement to act as a fiduciary, and therefore act in the best interests of the client at all times when providing financial advice. CFP professionals who operate under a wide range of compensation models tell us that what is most important to them is that CFP Board maintain high standards for competency and ethics while holding CFP professionals accountable for misconduct. This has driven a large increase in the number of CFP professionals. Regulators are responding in this way too by adopting fiduciary or best interest frameworks that address regulatory gaps that allow financial professionals to recommend financial products that are not in investors' best interest. The Department of Labor's Retirement Security Rule, which CFP Board supports, is the most recent of these frameworks. However, significant gaps and challenges remain, not to mention the least of which, of course, not the least of which is the stay of the Department of Labor's rule, but also those relating to some insurance products and the disclosure and mitigation or management of conflicts of interest, including cash and non-cash compensation, which CFP Board views to be among the most significant conflicts of interest. As I will discuss in my remarks today, the stakes of this discussion are high, particularly in the context of retirement. Investors frequently rely on financial professionals to help them make choices about investments, and in doing so, they assume that their financial professional is acting in their best interests. We should be matching those investor expectations. CFP professionals demonstrate that financial professionals from all corners of the industry can and are providing financial advice in their clients' best interest, including moderate income clients, while earning good livings and successful businesses. CFP Board first adopted a fiduciary standard in 2007 when it issued revised standards requiring a CFP professional to commit to CFP Board to act as a fiduciary when providing financial planning or material elements of financial planning. When we took this step, we were told that the number of CFP professionals would decline because of that fiduciary requirement. But instead of losing certificates, the number of CFP professionals since then has increased by more than 90%. We also heard that the number of CFP professionals would decrease in 2018 when we expanded a CFP professional's fiduciary obligation to all financial advice in our code and standards. In strengthening that requirement, we recognized that clients reasonably expect financial advice to be provided in their best interest, regardless of the CFP professional's business model. And far from losing CFP professionals, the number of CFP professionals has increased by more than 25% since that time. The demand for CFP professionals is strong. CFP professionals reach every corner of the industry, working in large firms and small businesses. Next slide, please. Advising 401k plans and individuals with only a few $1,000s to invest, and using a broad range of compensation structures, including commission-based compensation. And that includes 64% of CFP professionals who hold insurance licenses today. CFP professionals have shown that any financial professional who wants to act in their client's best interest is able to do so regardless of what products they offer or how they're compensated. And far from going out of business, our increased numbers and compensation data show that providing financial advice with a fiduciary standard is good for business. CFP Board's recent compensation survey shows that the increasing number of CFP professionals report compensation that is 10% higher than financial planners without the designation. Given the expanding number of CFP professionals from many corners of the industry, arguments that financial professionals are going to stop working with clients, particularly moderate income clients, if they're required to give advice in their clients' best interests, are contrary to our experience at CFP Board. Our experience shows that our standards have not restricted advice to investors, including the 64% of CFP professionals with an insurance license. Reg BI's requirements, which parallel those in the DOL's retirement security rule, also have not restricted access to advice. What has been restricted by the enactment of these standards and regulations is financial professionals' abilities to act on conflicts of interest or take unfair advantage of their clients. Next slide, please. Earlier this year, CFP Board conducted a survey asking CFP professionals how CFP Board's expanded fiduciary standard affected their business. The survey clearly demonstrated that CFP professionals continued serving their clients after we expanded the scope of the fiduciary duty to all financial advice. Specifically, after the adoption of that requirement, 90% of CFP professionals chose to maintain their current minimum investable assets for clients rather than raising it. That data also demonstrates the continued dedication of our professionals to serve clients from various financial backgrounds, including those from moderate income households. 42% don't require a minimum. Half of CFP professionals provide financial advice to clients with a household income of $0 to $75,000, and 2/3 provide financial advice to those with $75,000 to $150,000. The same survey, next slide, had similar findings about the adoption of Reg BI by the SEC in 2020. In CFP Board's survey, 4 in 5 CFP professionals who are personally subject to Reg BI or their firm is indicate that they have not raised the minimum investable assets threshold of clients that they are willing to serve. The survey also showed that Reg BI did not affect most CFP professionals' client rosters. 86% of CFP professionals report not terminating services to any of their clients as a result of Reg BI's best interest standard. When we expanded our fiduciary duty in 2018, we did so in response to the then growing body of evidence showing that consumers want and expect financial advice that is in their best interest. Given that all CFP professionals voluntarily commit to CFP Board to provide financial advice with a fiduciary duty, no matter if they work for a broker-dealer, an investment advisor, or an insurance company, investors engaging CFP professionals don't need to guess if their financial professional is providing financial advice in their best interest. However, given existing regulatory gaps, that is not the case for all financial professionals and all financial advice. Indeed, that undercover investigation that Eddie mentioned from the GAO about conflicts of interest revealed that even financial professionals themselves don't always understand what standard of care that they are providing advice under. Earlier this year, we also commissioned a survey of investors conducted by the Center of Economic and Social Research at the University of Southern California. The survey found that investors have trust and confidence in their financial professionals. 97% of Americans surveyed already expect that the financial professional who provides them recommendations or other advice will do so in their best interest. When it comes to one-time advice, such as a recommendation for an investor to move funds out of a workplace retirement savings program into an IRA or an annuity, 92% assume the financial professional who made the recommendation was required to make that in their best interest. The ever-increasing number of CFP professionals and data showing that CFP professionals are maintaining their services and clients, including moderate income clients, while being subject to a fiduciary standard is evidence that it can be done and that there is market value in being a fiduciary. So to those who are resisting or actively advocating or litigating against regulation that meets investor expectations to do what is best for them instead of the financial professional, I wonder why. What is so challenging? And why should they be subject to a different standard than the others who are providing the same or very similar services to investors simply because of the type of product that they're selling? Beyond that survey data, though, the personal stories that we hear from CFP professionals who often have clients come to them after receiving poor advice from another financial professional the clients assumed was required to act in their best interest, but was not, and made a profit at their expense. Given that the GAO in that same study found that 12 of the 55 professionals they asked about conflicts of interest said they did not have any, these personal stories are not surprising. The stories are even more impactful, and the collective stakes are even higher when they involve one-time advice, such as rollover recommendations. U.S. investors today have approximately $40 trillion in retirement assets. In 2019, investors rolled over $536 billion from employer-sponsored defined benefit plans or defined contribution plans to traditional IRAs. An investor's decision on how to invest funds from their retirement accounts can be the single most important decision in their financial life. Next slide, please. Yes, thank you. One of CFP Board's recent public awareness campaign advertisements demonstrates the significance of high-quality, one-time advice that is not tainted by conflicts of interest. Perhaps some of you saw this on TV. The advertisement presents an inexperienced bungee jumper who's about to take his first leap. The bungee jumper contemplates that irreversible decision to jump from the ledge, demonstrating the importance of having trust and confidence in the person assisting you. The bungee jumper didn't jump because he could see the frayed rope. But unfortunately, it is usually not so obvious to an investor that one-time advice a financial professional is providing is not in their best interest. Investors should be able to jump into retirement safely, knowing that all financial professionals are putting their interests first. Thank you very much. I look forward to your questions.
Thank you, Erin, and thank you, everyone. We have about 20 minutes for questions. So IAC members, I'm going to start with Paul Roy, and then please jump in with your questions afterward.
All right. Thank you, Paul, and thank you to our panel for great presentations and discussions. And I just had my own takeaways from the discussion and the materials that you guys provided, and then a question. Professor Hugh, in his materials, highlighted the need for greater cooperation among regulators to fight fraud and protect investors, and a uniform portal database on financial professionals, particularly where they've been suspended or barred or brokered. I would just note that Robert Cook may have read your presentation to us, because last week he gave a speech calling for greater coordination among regulators to fight fraud and this unified database that you're talking about. Also, it seems to me that given the fragmentation of the regulatory framework here and the confusion that investors have about what standards apply, it just seems to me the SEC and other regulators can do more to flush out what the actual differing standards are. And particularly, I'm struck by, on the insurance side, and the fact that the research that Professor Hugh and Colling and former Commissioner Jackson highlighted the fact that many sanctioned brokers then migrate to the insurance space and operate there. I'm not sure that a lot of the insurance regulators focus on the fact that these brokers even have information that they've been sanctioned and have issues. And so if that information can be shared and again, those standards flushed out for investors. I mean, Brian talked about the best thing to do is ask the financial professional what standards are they subject to, but it's very difficult for an investor to even go on investor.gov and see what the different standards are, and particularly even a voluntary standard like the CFP board that Erin talked about. So I think if more can be done to educate investors on what the differing standards are. And then the other thing that struck me, Professor Hugh, was the fact that a number of advisors who have been sanctioned by brokers, there you have duly registered brokers and advisors, a number of them continue as investment advisors. And I've rarely seen the SEC sanction an investment advisor by virtue of having violated FINRA rules. So maybe that's something the SEC should be taking a look at. I know I've seen some states bar brokers, financial advisors, because of their bad conduct acting as a broker. And then finally, what I would do is ask a question to you, Jason, which really goes to the fact that the NAIC rules don't make compensation a material conflict. And how is it that brokers who are have transaction-based compensation can navigate the conflicts with regard to compensation, mitigate and eliminate compensation conflicts, but insurance agents cannot? And then why is it that the NAIC model rule doesn't encompass annuities in a retirement plan space? That's excluded from the rule, which maybe is the reason the DOL wants to see a rulemaking in this space.
Oh, thank you for the question, Paul. And let me I'll take the last part first. The reason why, as I understand it, and that provision predated my involvement with the NAIC, is that the original version of the NAIC model was initially created in 2003, and it's evolved numerous times since then. But my understanding is that they excluded retirement plans from the scope in recognition of the fact that that was outside their jurisdiction. That they understood that the regulation of advice provided to retirement plans and plan sponsors is covered by the federal regulation of under ERISA. And so they tried to keep their focus limited to the space where they felt that they were appropriately responsible, which was the sale of annuity products to individuals. If that happens to be in the context of an annuity, of a retirement plan, that is not outside of the scope of the NAIC model. What is outside the scope are group annuities, something where the annuity contract is used as the vehicle for the plan itself. But to the extent that someone is a 401k owner or an IRA owner and they're using funds within that to purchase an annuity, I don't believe that that would be outside the scope of that, and I think those rules would apply. The other thing that they did do, though, is they included a safe harbor in recognition of the fact that there are other standards out there. And so if those transactions are happening in accordance with Reg BI or the investment advisor's fiduciary standard or even ERISA fiduciary standard, then that is considered to be compliant with the NAIC model. So you avoid that risk of duplicative regulation.
Compensation.
Compensation. So as I mentioned, thank you. As I mentioned in my remarks, it was perhaps not as artfully drafted as it could have been. And I think that that's something that will potentially become clear as the NAIC, I know, is considering possible future guidance to make this a little bit more clear. But I can tell you, I have spoken to the people who were involved in drafting this. I sat at the table with them when they were working on it. The intention was never to say compensation is never a conflict. That is how it has been spun by those who are in favor of the DOL model. But in reality, if you contact any member of the NAIC, any insurance regulator, they will acknowledge that if there is a conflict related to compensation, that is something that would be subject to and expected to be dealt with under the conflict obligations imposed under the model. And it's also subject to the extensive disclosure requirements. And the model also includes a prohibition on sales contests and similar conduct along the same lines as what the regulation best interest has. So, I think there's this sort of narrative that's out there that the NAIC doesn't care about compensation conflicts, and that's simply just not true.
Well, I mean, you explicitly say in the model rule that compensation is not a material conflict. So, to sort of spin that as people misinterpreting what's in the actual model, and then when yes, you require disclosure, but if you look at Reg BI and the advisor fiduciary duty requirements, yeah, they require disclosure, but there's an overarching obligation to act in the investor's best interest, notwithstanding disclosure of the compensation.
I would argue that the NAIC model has the same thing. The top line obligation, the core of the NAIC model, is virtually identical to Reg BI. An insurance producer.
Why exclude in the definition that a material conflict is not compensation? Why is that in there at all?
Honestly, the best thing I can explain to you, Paul, is that the NAIC functions in a very open process, and so the drafting was done in a meeting room, very much like this, with people from all different perspectives, including regulators on both sides of the aisle, industry representatives, consumer representatives, and as you have a large group of people with a lot of different opinions working on something, it becomes very, very difficult to get exact language precise to the way that you're intending it. But I can tell you that the way that it is being enforced and implemented across the states is not to say that compensation can never be a conflict.
So New York was explicit in its annuity rule that compensation is a conflict, and in New York, you have to deal with that issue. I mean, it's very explicit.
New York also didn't wait for the NAIC to finish its work.
Okay, thank you.
Thank you. Thank you for the question. I'll go Jamila, then Brian, then Christine.
Thanks, Paul, and thank you to the entire panel. This has been a great discussion. I want to start with Dr. Eddie Hugh. Your comments on the fixed annuities and that regime just took me back to some of the abuses we saw with variable annuities, right? And obviously there's a lot more oversight there based on what you shared. You talked about fixed annuities being complex, but do you feel like they are the same way route with fraud, can be abused from a commission standpoint? Is there evidence of that? And then the second question is there any, and I know Jason may have a view on this, are the commission regulators, or is there any type of like reporting that goes out there? I mean, this is a black mark on your record from a FINRA perspective when you do have these abuses. What is in the insurance regime for something like that when we think about comparing it to what we saw with VAs over the course of the years?
Yeah, that's a great question, and I'll start in reverse. So, as you mentioned, in the advisor and the broker regime, we have great tools for looking up brokers' past conduct records. And as academic work has shown, this information can be very useful if investors know how to use it. And so FINRA has done a great job of promoting knowledge of BrokerCheck as a potential tool. So you might think that this type of tool might also be useful for insurance customers, but based on our recent efforts to collect this data, no such product exists. In fact, we reached out to all of the states, and the only state which gave us individual conduct data that was of any use was Texas. And that wasn't because they had a portal like BrokerCheck, it's because the state has an open data portal that is very useful for an economist to write code and download data and study these things, but pretty useless for the ordinary investor. And in some recent work that we're doing right now, we actually show that one of the most significant predictors of investor harm in the insurance market is, again, whether you're dealing with an insurance producer that has done that in the past. And so that information is going to be very useful, and hopefully what FINRA is doing to expand, potentially creating a unified database will help a lot, I think. As for the potential investor protection concerns in the fixed index annuity space, as with any complicated financial product, it's something where investors can benefit a lot from having expert financial advice. The best way to think about a fixed index annuities in some ways, from like a pure economic standpoint, is that it's basically like investing in a mutual fund and a series of options collars. And so that's quite complicated, and investors probably need some help. I have a PhD in finance, and I couldn't tell you how to price some of these things efficiently. And so I would be very concerned about the potential conflicts of interest, investors not understanding, the withdrawal penalties and the fees. And so I think a lot can be done to improve, financial advice that folks are getting in that space.
Thank you so much. That was great. And I'll be really quick, Paul. Jason, of course, would love any rebuttal to that, but also I'm not going to pick on you about compensation. I am going to go to your points on financial inclusion and the underserved community being excluded based on the proposed rules for 2024. The balance between protection and exclusion. I'd love to hear your view, the NAIC's view on this, because that was fascinating. I mean, the Deloitte study, 53% not having brokerage access, like that seems extreme. And, where is the balance here, or is there a perspective that you all have?
Yeah, so Yeah, I think that there is a place for balance, but let me first address the first part, which is the concept of a database where consumers would have access to information about their financial professionals. That is a great idea. I don't have a problem with that. We as an industry want bad actors out of our industry. I don't want someone out there selling an annuity to a consumer who is doing it just to line their own pockets. I want them selling the right product to the right person for the right reason and being compensated fairly for their services without having to worry that they're going to be dragged to court as part of some sort of class action litigation. We've seen opportunistic litigation firms out there that have pursued opportunities to leverage some of the restrictions within ERISA to effectively benefit the plaintiffs' firms and give their pool of clients each a little tiny slice of that. But to me, that is the real crux of the difference here between being an ERISA fiduciary and being subject to a best interest standard like what you have under Reg BI or the NAIC model, because both require you to act in your client's best interest. You cannot get around that. Every financial professional who is subject to Reg BI or the NAIC model has to put their own interests second to their clients. The consequences is where it comes into play that it's different. And so that's why when I hear about CFP board saying, hey, we're seeing increases in our roles, that's great. This is a voluntary system. I think it's a great standard. I don't believe it's correct me if I'm wrong, Aaron, but I don't believe it's enforceable in private litigation. So you're subject to potentially losing your CFP certification if you violate it, just like you would be subject to losing your securities license if you violate Reg BI. So to me, it's the consequences, not what's required, that is where the difference falls. Remind me of your second part of your question.
Just the balance between kind of the exclusion. Right, you got it now.
Yes. So, look, I think the way we look at this is every American needs access to the right type of advice. They need to have the ability to talk to somebody who they can trust, who they can rely on. There is a difference, by the way, between being able to trust someone and having a relationship of trust and confidence. Those are two very different things that have been completely muddled in the course of this debate. I trust the person that cuts my hair. I don't think that I would consider her my fiduciary. We don't want to see rules put in place in the interest of addressing hypothetical risks, because I haven't seen a whole lot since Reg BI and the NAIC model have come out to suggest that there are still gaps that are being exploited. They're hypothetical, right? So in the interest of addressing these hypothetical gaps, we're putting rules in place that are going to make it harder for anybody to get access, especially those on the lower end of the income scale. And that's where we know, that's one of the failings of our society, is that tends to be more in those underserved communities, right? Those are the people who need to be given the opportunity to hear what are the risks I'm facing? How do I manage those? How do I make sure that I've got enough money so that when I'm in my golden years, I don't have to worry that I'm going to be destitute, right? Putting these rules in place without thinking about how they're going to impact those lower income communities is irresponsible. And I haven't seen any significant studies to address that other than this one study by Quantria that found that this would actually exacerbate that problem.
Thanks so much.
Appreciate it. Real quick to Brian Helmer.
Yeah, I have to say I'm surprised that there's still industry resistance to higher levels of fiduciary protection for investors. In my personal experience in various firms, we've always grown when we've put more fiduciary protection in place, whether it's through certification of the professionals on the front lines or whether it's through regulatory changes. So it is, just as a comment, it's surprising that the very thing that helps grow the industry and has not really ever been shown to limit access is still being fought by certain pockets of the industry. So I find that surprising and very misguided. Question. To the degree that Paul brought up the idea that part of the challenge under the way that things are working is the need for clarification and coordination between regulatory bodies, does anyone on the panel have a specific recommendation or a series or a couple ideas on how we could frame that kind of recommendation to the SEC? What exactly would be the type of idea that would begin to address that lack of coordination and clarity that we seem to be struggling with?
I can, just to comment, this is something that we've been concerned about at CFP Board and advocating should be put into place. Jason and I have spoken about this separately, that we can both be on board with a database that would provide information for investors to protect themselves. I don't have the answer. I know that Christy Romero-Goldsmith from the CFTC has proposed something similar having to do with financial fraud. And I'd say that we're committed to working on that with those who are interested and would love to push it forward.
And I could just tell you, having spoken to leadership and members of the NAIC and the state insurance regulators, they want to be part of the system. They want to be involved. They very often find themselves on the outside looking in. They were, in the course of the DOL's efforts to develop their this rule that's now on hold, they were contacted briefly at the staff level and never had any meaningful substantive discussions about how the NAIC model actually operates. Instead, the DOL just looked at it, read it, decided they didn't like it, wasn't good enough, and decided that it was their job to replace it effectively. So I think it really comes down to there needs to be a commitment from across all of the regulatory bodies to working together, to collaborating, to not having this, federal state bifurcation. I think it's great that NASA is represented at the table, bringing that state perspective. The state regulators are a critical part of the overall regulatory framework. They need to have a seat at the table and not just as a token. It needs to be meaningful, because otherwise you have misconceptions about what is really happening at the state level.
You have 1 minute.
Oh, sure. So we've also tried to get data from the NAIC about registrations and conduct, and their answer was, no, basically. But also, I think on the regulatory coordination front, one thing that we've written about in our papers is regulators could do a better job of disclosing any referrals they make to other regulators. So FINRA and the SEC have a pretty good working relationship, and FINRA will disclose basically the list of all of the people that they've referred to the SEC. And you can kind of look across that to see, is the SEC taking action against people that FINRA believes might be problematic. But we've heard that, state securities regulators often make referrals to, their insurance colleagues and essentially never hear back and nothing ever happens. So that's an area that I think could be greatly improved.
If I could just go back to Mr. Roy's question at the beginning and sort of call out one of the roadblocks that perhaps exists here. It's ERISA preemption and other federal preemption. I was not at the table when NIAC was making their rule, but one of the reasons that a lot of state regulations have carve-outs for ERISA is because of ERISA preemption. If they are preempted by ERISA because they've touched upon ERISA plans, the entire rule goes down. And so by carving out ERISA, they've tried to sidestep that preemption issue, but that means that you don't necessarily have an across-the-board solution.
Thank you. Allison, thank you. The rest of the panelists, thank you so much. I'd like to thank all of the panelists and all the participants of the committee for the rigorous conversation and discussion. I'd like to thank Paul Summerstead, who moderated this, for his terrific job, and the Purchases Subcommittee for sponsoring. We'll be breaking now for lunch and for an IAC executive session, and the public portion of our meeting will resume at 1:40 p.m. Thank you.